Hi there. Thank you for watching. And for those of you who have been tuning into our live stream, you know the big news of today. Julian Assange had his appeal hearing in London at the UK High Court and learned that he has been granted permission to appeal. It's a partial appeal, and it doesn't mean that the appeal will be granted, but he's been granted permission to appeal the case. So we're going to now go to Chip Gibbons, reporting for Jacobin magazine, policy director at Defending Rights and Dissent, who was in court today and can talk about what he saw. Chip, can you tell us what you saw today?
Sure. I was in the courtroom today in the overfill room during the hearing. So what happened was we had this ruling in March that in a lot of ways was a very abysmal ruling. It denied many of Julian Assange's potential grounds for appeal and granted three extremely narrow grounds for appeal. One was over the assurances of the death penalty. One was over whether or not his free expression rights under the European Human Rights Convention would be violated if he was not allowed to rely on the First Amendment. In the same ruling, though, they stated that prosecuting him for revealing war crimes would not be a free expression problem, and that they made these bizarre statements that only three of the charges had anything to do with the First Amendment, the rest were ordinary crimes. And then they also discussed the issue of him facing unfair prejudice due to his nationality. Both the nationality and the relying on the First Amendment comments come from comments made by Gordon Kronberg. Kronberg is the prosecutor in this case. He prosecuted Daniel Hale. He was involved in, I think, the tail end of the Sami El-Arian prosecution. There were so many different phases to that persecution. I can't remember which ghoulish national security figure was in which phase. But a person with a really notorious history of anti-Muslim bigotry, of bringing in abusive prosecutions. And he told the court in a sworn declaration that the U.S. might argue that Julian Assange was not entitled to First Amendment rights as a foreign national, at least as it pertained to national defense information. Now, that means, the U.S. is saying, oh, we can prosecute him. Oh, we can prosecute him. We have this robust First Amendment. We can't rely on that. And it means you are treating him differently based on his nationality. So at the start of today's hearing, the defense acknowledged that they found the death penalty assurance sufficient, so that the death penalty issue is no longer in play. The Secretary of State had a lawyer present. The UK Secretary of State, not Anthony Blinken, had a lawyer present who said, we just asked you to remove the death penalty thing. So all of the sides agreed that was met. But the defense argued that the First Amendment and nationality discrimination assurances were not met. They argued that saying he can seek to rely on the First Amendment does not mean he can rely on it. They also noted that Gordon Kronberg never promised to not raise that argument, that there was no First Amendment protections for Assange as a foreign national. And they argued that even if Kronberg did not raise that argument, a court could still independently come to that conclusion. They had their own expert who made those points. And then on the foreign national issue, the United States government put up this preposterous it was the UK government representing my government, put up this preposterous defense that there's a difference between citizenship and nationality. Yes, I know that's true. Thank you very much. And that Assange would not be discriminated against as a foreign national, but as a matter of law, he's a foreigner. Right? At one point, they literally said this isn't Assange being discriminated against because of his nationality. It's just a matter of law. He's a foreigner on foreign soil. Of course, if he's a foreigner on foreign soil, why are we extraterritorially applying the Espionage Act to him? That's a good question to me. But whenever you're saying we're not discriminating because of his nationality, we're discriminating because he's a foreigner, I think you've sort of lost the argument. And the defense argued that these types of arguments were new. They had not been made at previous stages, and that there should be a hearing on them. the judges adjourned for what was, Stella talked about this during the press conference, for what was supposed to be the press conference, or not for the press conference, to come back and tell us where we're at, which caused quite a lot of humor in the press room when people were answering. We know where we're at. We're at the Royal Court of Justice, because no one knew what this meant. Like, we'll come back in 10 minutes and tell you where we're at. Like, we're on planet Earth, we're in the Milky Way, we're in London. What does that mean? And at some point, one of the journalists in the press room said out loud, "It's been 20 minutes, they're making a decision." And when they first went away, there was a big not a debate, a discussion back and forth of those of us in the press room about whether or not this meant they're making a decision, or whether they would just come back and say, "We want to hear more facts," or, "Why don't we have lunch?" But after we hit the 20-minute mark, it was clear that they were going to make a decision. And I'll be very honest, I was pacing because I was not expecting this outcome today. Given the degree of, in the March decision, just sort of the degree of negative things for Assange's case, including that bizarre Article 10 analysis, separate from the Gordon Kronberg issue, where they stated only 3 of the charges pertained to freedom of expression, and those publications had no public interest, including when they said Julian Assange's defense can no longer bring up the fact that the CIA tried to kill him because, well, if we send him to the US, they won't try to kill him, right? This was the level of decision. And what I was reading was, they were very much interested in rubber stamping this, and Gordon Kronberg just did such a terrible job. They couldn't, and they were telegraphing with these assurances. And you have to remember, Julian's attorneys to date were fighting with both hands tied behind their back because of all of the limitations that have been placed on them. This extradition should have been squashed 5 years ago under the political offense exception to the treaty, but they've now decided judges can't rule on that in any treaty anywhere. So it's just every single ruling, even when the law is on Julian Assange's side, they rule against him. And on a number of the key issues, the judges have buried their head in the sand. So during that 20, 30 minutes, I really thought they were going to come down and give us the worst possible news. And then they come back and they say, we grant appeal right on leave to appeal on 4 and 5 and denied on this. And everyone's, getting out the list of appeal grounds and trying to figure out what's what. But
right.
Yeah. So I'll stop there. Other people want to talk, I'm sure.
Thank you, Chip. I appreciate you bringing in your perspective from the courtroom. It's great to finally have a ruling that goes for Julian's way. It's been a long time since we've had one of those. It also, unfortunately, means another day in prison for this aging and ailing publisher. Marjorie Cohn is also with us, past president of the National Lawyers Guild. We're also going to hear later from Stephen Rohde, a constitutional lawyer and a former head of the ACLU in Southern California. Marjorie, we know that the parties have been given 4 days to provide an outline for the appeal hearing that has been granted the right to appeal for. Can you talk to us about what the next legal steps are going to be and what this means for Julian coming up?
Yes, Nathan. Well, the bottom line is that Julian Assange's appeal is still alive, and that's the best news. By May 24th, the court said the parties will present an outline of how the hearing will go, and he has now been granted a hearing on these 2 issues that the court said are pivotal. Then, once the 2 parties present an outline of how they think the hearing should be structured, the court will set a hearing date and a structure for the hearing. At that hearing, there will be witnesses called, evidence presented, legal arguments made about the statutes, the treaties, the case law, and the requirements of Article 10 sub 1 of the European Convention on Human Rights and Article 81B of the UK Extradition Act are the 2 legal issues that the court is concerned with. And I want to just briefly read those sections. Article 10 sub 1 of the European Convention on Human Rights says, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive to receive and impart information and ideas without interference by public authority and regardless of frontiers. That's in the European Convention on Human Rights. And then the other issue is based on Article 81B of the UK Extradition Act, and it says that extradition is barred for an individual who might be prejudiced at his trial or punished, detained, or restricted in his personal liberty by reason of his nationality. The focus on that hearing will very likely be the doctrine of separation of powers in the United States, regardless of what the prosecution says that Julian Assange can admit in terms of evidence. It is only the judicial branch, the courts, that decide on the admissibility of evidence. And I know that Steve is going to get into the details of the legal arguments, but that's the structure. So we'll have to wait until the 24th, and then the court will consider the proposals by each side, the government and Julian Assange, and set a hearing date and the contours of that hearing.
Thanks, Marjorie. Stephen, a constitutional lawyer, as I said, a past head of ACLU SoCal. Stephen, thanks for joining us today. Could you give us your interpretation of this ruling and what you think is going to come substantively in this appeal hearing?
Thank you very much. May 20, 2024 is an important date. It's an important date for Julian Assange, and it's an important date for press freedom around the world. It's very important to understand the United States' approach to this issue, and they've been forced by Julian's lawyers and the arguments they've advanced, but forced by these two UK judges to come clean on the US position on freedom of expression as it applies to Julian Assange. These two judges cut through the deference that has been paid to the United States throughout this proceeding, an extraordinary amount of willingness to accept the word of the U.S. government at face value. Let's never forget that originally the extradition request was denied because of fear of Julian's treatment in U.S. prisons and the risk of suicide. And that was cast aside by assurances from the U.S. government. Well, somehow in the last several months, these UK judges have seen through the artifice and the pretending of the U.S. government. And that itself is very important. On the world scene, the deference to the United States is giving way to a more realistic assessment of where the United States stands in international relations, and in this case, in the area of freedom of expression. There was a very terrifying moment for any journalist in the courtroom today when the QC lawyer representing the government of the United States, James Lewis, said the following, and it is U.S. journalists who should be terrified by this statement, irrespective of how the case turns out regarding Julian Assange. Lewis said that Assange's conduct is simply unprotected by the First Amendment. Quote, no one, neither U.S. citizens nor foreign citizens, are entitled to rely on the First Amendment in relation to publication of illegally obtained national defense information, giving the names of innocent sources to their grave and imminent risk of harm. First of all, that statement is misleading and contrary to the evidence that has been adduced at the Chelsea Manning trial and elsewhere that Julian Assange posed any risk regarding the names of innocent sources. But it is the first section of that statement that neither a foreign journalist nor a U.S. journalist has any right to rely on the First Amendment when it comes to the Espionage Act of 1917. Now, the way that this case has played out, if all it was a U.S. case, at this stage, that might be the end. But because we are in a UK court, and because the European Convention of Human Rights presents an umbrella of rights that overlie all of the treaty and legal issues in England, it is the European Convention of Human Rights that prevails. And it is the fourth ground for appeal in this case that I think may ultimately bear the greatest opportunity for Julian to defeat extradition. Because as Marjorie explained, Article 10 is an absolute protection for freedom of expression. In fact, it's so absolute it begins with the word everyone. Everyone has the right to free expression. This does not turn on nationality. This does not turn on foreign citizenship. Everyone has that right, and this prosecution is violating that right. There is now almost a direct syllogism that the government says there is no free expression protection for Julian or any journalist. I think this is the seeds of the end of this prosecution. Now, it will take a long time. They have to agree on a pleading schedule on May 24. There will be legal filings. There will be hearings. I dearly hope the UK system understands by now that Julian should be released into his own recognizance. He should be with his family pending appeal, and that takes place. But ultimately, I think the grounds now exist for this court to realize that this request for extradition violates Article 10 of the European Convention on Human Rights, and that is the pathway for vindication by Julian Assange and for press freedom.
Thank you, Stephen. And just to underscore that point, the point is that Julian would get more protections under the European Convention on Human Rights, because, as you say, it protects everyone, than he would get here in the United States under the First Amendment. Chip, I'm wondering if we could come back to you and discuss any case law. Is there any precedent for that kind of protection preventing an extradition? Oh, you're muted, Chip.
Well, I was saying I don't actually know the answer to that question. I don't know how. I'm not an expert on European extradition, and my expertise is in the U.S. First Amendment. I'm learning about U.S. extradition as our government continues this 5-year-long attempt to bring a political prisoner to our country and persecute him. But I don't know of any case law specifically on that point.
And I'm wondering, Chip, if you could just give your sense of the judge's questioning, and if that might give us any kind of preview for how the tenor of the appeal hearing might go.
Judges were almost completely silent. I don't recall them asking a single question. And then there was this moment at the end where they started whispering on a hot mic. And the only word I could hear was discrimination on the hot mic. And then they said, we'll come back in 10 minutes. And they came back in 30 minutes. They were very mute. It was very hard to read them.
Interesting. And Stephen and Marjorie, please do come in if you have any knowledge of that case law, or if there isn't such a precedent. But Marjorie, maybe you could give a feeling for whether you're optimistic or pessimistic. It sounds like Stephen is feeling like the blueprint is starting to be laid for how this prosecution and extradition could be undone. Where's your feeling on that?
Yes, I think this is a very, very positive sign. These two judges could have, like judges before, many of the judges before them on the high court, dismissed the arguments and they could have said, we accept the U.S. assurances. They're acting in good faith. That's what the high court has said in the past. The difference here, though, is that these two judges didn't just accept those so-called assurances by the U.S. government at face value, the way their brethren did before. They gave Julian Assange an opportunity to answer that question and set this hearing. Now, I do want to say that the U.S. Supreme Court on this issue of whether or not a foreign national can raise a First Amendment issue in his trial, the U.S. Supreme Court ruled in 2020 in the case of Agency for International Development versus Alliance for Open Society International that, quote, "It is long settled as a matter of American constitutional law that foreign citizens outside the United States territory do not possess rights under the U.S. Constitution," unquote. They're going to have a very hard time, the U.S. government, getting around that Supreme Court case, which is a very recent ruling from the Supreme Court. Also, the two judges who made this decision in this hearing had determined that the First Amendment is central to Julian Assange's defense, and that if he is not allowed to raise that would be prejudicial. And I think that's key because as I said before, the separation of powers doctrine in the United States says that the judge, courts, not the prosecutor, the executive, have the right to determine the admissibility of evidence. So I just don't see, if these judges honestly consider these issues, I just don't see how they are going to deny Julian Assange's right to appeal and throw out this argument in order that he be extradited.
Thanks, Marjorie. Stephen, you wanted to come back in on this question.
Yes, I think it's very important to distinguish between these two arguments. First, that Julian head-on has the protection of free expression under the European Convention. The U.S. is playing a very dangerous game because they are addressing the question of discrimination between nationals by having the audacity to say U.S. journalists have no First Amendment protection under the Espionage Act. So they've put down all their cards. They're saying there's no discrimination. We're going to deny Julian a First Amendment defense just as much as we would deny a U.S. journalist a First Amendment defense. And frankly, in that sense, they are right because, as Marjorie has indicated, there are some lower court decisions that do not grant a First Amendment defense under the Espionage Act. This case would have set a precedent to challenge the Espionage Act directly as a violation of the First Amendment. But I think the stronger grounds is the head-on challenge under Article 10, and that the cynical approach the U.S. government has taken has been exposed, and that this high court will see through that and will hold that in this case, the European Convention on Human Rights is a higher law than the U.S. Constitution, at least as it affects a UK proceeding for extradition. And frankly may leave to another day in the United States a challenge to the Espionage Act under the First Amendment.
Can I
Thank
just
you,
add
Stephen.
one,
Please
Nathan?
do, Marjorie.
Yeah, I want to underscore what Steve just said because it's really, really critical. In the United States, we are not accustomed to looking at courts outside of U.S. courts. Our government poo-poos its treaty obligations and doesn't take them seriously, notwithstanding the Supremacy Clause of the United States that says treaties shall be the supreme law of the land. But in the UK, it is different. The UK is bound by the European Convention on Human Rights and the European Court of Human Rights. And there have been instances where the UK courts have made decisions which have been overturned by the European Court of Human Rights, and the UK courts have to go along with that. So I think we need to keep that in mind. We're not accustomed to these this so-called international law, which is actually part of U.S. law, but our judges, many of our judges, don't seem to have to understand that. So this is really important that this issue, one of these two issues on which Julian Assange has been granted leave to appeal by the High Court, concerns the right to freedom of expression under the European Convention on Human Rights.
Thank you, Marjorie. It's a really important point. And all three of you are, of course, experts on this case, but also on the Espionage Act. But Chip, you've particularly been working on this for years now. You've been heavily involved in efforts to reform the Espionage Act to try to bring in a public interest defense. Can you talk about the U.S. prosecution's comments about the First Amendment and the fact that even U.S. nationals shouldn't expect First Amendment protections? Can you contextualize that in the history of this Espionage Act repression?
It's not surprising because the U.S. has always maintained that Julian Assange's conduct, and I don't agree with this, obviously, is outside the scope of the First Amendment. It's outside the scope of journalism, that Julian Assange is accused of aiding and abetting, that he's accused of transmitting or publishing national defense information. So that's not at all a surprising argument, even a little bit. And I believe at one point during the trial or the hearing today, they mentioned that Chelsea Manning was denied a First Amendment defense, noting that why then would someone who was complicit in what she had done, obviously it's between a journalist and a source who was complicit in what she had done, why would she be granted a First Amendment defense? I mean, it's really important to remember that, I mean, when it comes to these sorts of issues, the First Amendment and the Espionage Act, the First Amendment is a matter of law, not a matter of fact. So it's not something a jury would ever decide whether or not this violated the First Amendment. What happens is before the trial, someone, and presumably if Julian goes to the U.S., Barry Pollock will challenge the different charges on the basis that they're facially unconstitutional or they're unconstitutional as applied. And that would also come back together during the sentencing phase when they would likely argue, if that had failed, that the court has to prove a higher level of intent. As far as, whether or not, as far as the U.S.'s comments, they're disturbing, but it's also worth remembering that in the March ruling, the judges who made this decision conducted their own Article 10 analysis absent the Gordon Kromberg comment of the case against Julian Assange, and they completely mirrored what the U.S. government said. They said that only 3 of the charges had any First Amendment, had any press freedom application. The remaining charges were routine criminal conduct. Obviously, I reject that very strongly. And in the 3 charges that did have a press freedom aspect, there was no public interest in publishing them. So the UK court hasn't actually differed from the US in how it applies protections for free expression to the publications themselves. The issue has always been about the Kromberg comment about whether or not and this is why I was expecting us to lose today, because they do seem kind of hostile. It's always been about the Kromberg comment about they would argue as a foreign national, he can't rely on the First Amendment. And then what does it mean to rely on the First Amendment is I think, an open question. And they're going to have a hearing on that. And we'll see what they decide then. But I today was absolutely a victory. We absolutely should be celebrating. We don't get enough victories, but I do really want people to be cautious. And my understanding is that Article 10 includes a balancing test. At least that's what people have told me. I'm not an Article 10 expert. And that ruling they made in March did include a balancing test that they did. And again, I don't agree with the ruling, but it's worth pointing out that they have not shown themselves sympathetic to press freedom issues at all beyond this particular point.
Thank you, Chip. And just to be clear on that, so the 3 charges that they're saying are implicated here are the 3 publication charges, and the remaining ones then are attempts, I guess, to criminalize the soliciting, but also the obtaining, the receiving. Is that right?
There's three categories of Espionage Act charges against Julian Assange. The court made it into two categories. It's three. Some of them are areas where they're trying to impose liability on Julian Assange for actions that Chelsea Manning is alleged to have committed. For example, one of the charges is aiding and abetting Chelsea Manning in giving information she had authorization to someone who did not, Julian Assange. Julian Assange never had authorized access to this information. It's an absurd charge to bring outside the aiding and abetting sphere. On top of the aiding and abetting charges, he is also charged with the receipt of national defense information. And as the defense argued correctly, that the First Amendment does not just apply to publishing, it also applies to news gathering. And in order to publish something, you have to receive it. And then there's the third category of charges, which are the so-called pure publishing charges, where there is no aiding and abetting, and there is, it's not over the receipt of the information. It is explicitly Julian Assange had this information and he put it on the internet. And what the court does there, and this is a legal fiction that I vehemently reject, is to try to pretend the pure publication charges, which I believe are the State Department cables, the Iraq war logs, and the Afghan war logs. I might be wrong. I have this all on a cheat sheet somewhere, but I don't have my cheat sheet in front of me. Is that they're only being criminalized because there were names of informants. Of course, we know there is a separate statute in the U.S. that covers that sort of information that does not apply to Julian Assange. Congress explicitly chose not to cover that type of material. Of course, we know it is a lie to say he was careless. He went through all of these different steps to protect the sources. And of course, we know that the Pentagon Papers included the names of sources. So there's so many. And of course, it is a legal fiction to try to separate out the entire publication from these minor things. So that is what the court has done in its past. And in a lot of the arguments they made, they are almost verbatim what Kronberg has said.
Thank you, Chip. Stephen wants to make a final point on this question, and then we're going to be running out of time. So then we'll go to Marjorie Cohn for a final comment. But Stephen, come in on this.
Very briefly, today is a day to celebrate, but I'm not sure we have the keys to the courthouse yet releasing Julian Assange. What's sobering is they're buried in this indictment are charges under the computer intrusion statutes of the United States, separate from the Espionage Act. It remains to be seen whether the High Court will see a free expression defense to the computer intrusion charges. It would be the tail wagging the dog to extradite Julian solely on the computer intrusion charges and not on the Espionage Act, but that's certainly a possibility. Secondly, I want to emphasize how dangerous the Espionage Act itself is to American journalists. This is a loaded gun above the mantle that is faced now at all journalists, because the Assange indictment breaks through the distinction between the leaker and the whistleblower on one side and the publisher on the other side. It's what makes the Assange prosecution so unprecedented for the Trump administration and now the Biden administration to go after a journalist. All of us who care about press freedom need to understand the potent weapon that is emblemized by the Espionage Act. There's a terrific book on the Espionage Act by Ralph Engelman and Carrie Schenkman on a century of repression. It's required reading for anybody who cares about press freedom and the Espionage Act. Finally, there's the work of everybody watching this press conference and this analysis. We cannot sit back on our hands. This is a political prosecution. Chip has made this point. Others have made the point, and therefore it is political. And letters and phone calls should be made to the White House, to the Justice Department. The provisions in Congress of H.R. 934, the bipartisan resolution defending Julian Assange should be supported across the political spectrum, regardless of the various sponsors of that bill. We have to use this moment, as the Australian government is using this moment, as the British legislature is using this moment, and as press freedom groups across the world are using this moment. The writing is on the wall, and we should support the defense of Julian Assange and call for his release.
Thank you so much, Stephen. I'll just note that Democratic Representative Chuy Garcia just joined on to that HRES 934, which calls for dropping the charges against Julian Assange. You can find out more about that and how to get involved at AssangeDefense.org. There's a take action button with a whole lot of different ways to take action. You can call your Congress member, you can text, you can write a letter to your editor. There are a whole lot of ways. We're just going to go to Marjorie Cohn now, former president of National Lawyers Guild, for a final comment on today's reaction panel. Marjorie, take it away.
Yes, Nathan, it's important to remember that Barack Obama, when he was president, prosecuted more whistleblowers under the Espionage Act than all prior presidents combined. But after a secret grand jury determined that it would violate the First Amendment, the Obama administration declined to indict Julian Assange. Well, it was Donald Trump who actually filed the indictment against Julian Assange and started this whole process. And if Joe Biden were honest, and he loves to attach his coattails to my buddy Barack, he would have followed through with what the Obama administration did, the Obama-Biden administration, and dismiss this request for extradition and dismiss the appeal. But instead, the Biden White House, the Biden administration, the Department of Justice has gone full speed ahead in pursuing Donald Trump's indictment of Julian Assange, and all of these things that Steve and Nathan mentioned about what people should do also barrage the White House and the Department of Justice with reminders about how critical it is to follow what the Obama administration did and drop the charges. The Obama administration was concerned with the so-called New York Times problem, which is that WikiLeaks did nothing different than the New York Times and Der Spiegel and the Guardian, etc. And that was to publish classified information. In fact, I think it was about a year ago, maybe a little longer, 5 of those newspapers that published what WikiLeaks did called for the dismissal of the Espionage Act charges. So Biden should continue with that enlightened policy and correct policy of the Obama administration, dismiss this request for extradition, and drop these charges against Julian Assange once and for all.
Thank you, Marjorie. And
I'm applauding you, Marjorie. I'm applauding you. You can't.
And the UK court is
applauding. Yes, that was
giving the U.S. an opportunity to do that. Wholeheartedly agree. And I want to thank you all for watching our reaction panel, and thanks all for watching our live stream today. Thank you to Matthew Ho, Chloe, everyone on the UK team for doing such a great job. Thank you to our panelists today for commenting on this really important development. Please continue to stay tuned for coverage, AssangeDefense.org. Thanks so much, everybody.